There's a time.
لما بنفطر كمان ما بنلاقي شيء قدام. Empat daripada
Welcome, Michelle.
It seems like all of our speakers have arrived. Good morning to three of you. So, ladies and gentlemen, we are about to begin our workshop. Before we get started, I have a few housekeeping notes to make. First, I would like to seek your cooperation in completing this workshop and kindly mute your microphone to avoid interruption. Thanks for your kind cooperation and attention. So good morning everyone, welcome to our online workshop. My name is Chase, first year UNIZA LLB student, and I'll be your MC for today's workshop. On behalf of all committees, I would like to welcome all of you. We appreciate you taking time off your busy schedules to join us today. Before we begin, I'm gonna explain a little regarding international law mooting. It is a simulated court proceeding where law students or lawyers argue a hypothetical case based on international law before a panel of judges. This exercise helps participants improve their advocacy, research, and public speaking skills. Mooting is a challenging but rewarding experience that helps to prepare law students for a career in international law. As you all know, we have an excellent lineup of speakers and topics today, and I'm sure you will find the information they provide to be informative and valuable. After the presentation, we will have a short Q&A session. So today, we are very much honored to invite three experienced mooters, and for your information, all of them are the champion of the 2023 Philip C. Jessup International Law Moot Court Competition of the national rounds. Let me introduce our first speaker, Ms. Ko Shu Hwan, who's now a final year law student at Brickfields Asia College, and she was the best oralist in champion of the 2023 Philip C. Jessup International Law Moot Court Competition that I have mentioned just now. Our next speaker, Ms. Michelle Wong Jia Ling, who's currently a barrister training course candidate at BPP University in London. Our final speaker today, Mr. Stanley Koh, who's also an outstanding mooter. He's now a BAC final year law student as well. They will go through some fundamental topics, which are introduction to mooting, international law mooting, preparing for moot competition, presenting oral arguments, and the tips for beginners. We'll get a general overview of international arbitration moots and tips on written and oral advocacy through the session. To begin this program, let's welcome our moderator for the workshop, Ms. Umasri Anak Perempuan B. Ravindran, who's currently a first-year UNIZA LB student.
Thank you so much, Kay.
Without further
Thank you so much
ado,
for the
let's
introduction.
proceed to the discussion. Our moderator, Ms. Umasri, will now take over.
All right, thank you. So good morning, everyone. My name is Umasri. I'll be the moderator for today. First of all, I just want to thank all of you for joining us. We're so excited to have you here. Let's just before we dive right into it, I wanted to talk a little bit about our upcoming book club competition. It is called the 2023 ILSA UNIZA International Law Book Club Competition, and this competition will be is being organized in May of this year, and this workshop is actually being organized as preparation for this competition. And here in UNIZA, some of you might know this, but we actually have a little bit of a drought of mooters. We find it difficult to find mooters, to find law students who are actually interested to join competitions, and thus we hope that through this workshop, we get to encourage more law students to join competitions, as well as to join our international law moot competition that will be on May. So let's dive right into it. Maybe let's get to know the speakers a little bit better. So how are you guys today?
Great. Michelle, you wanna?
Yeah, I think Michelle is in the best position to say how she feels.
Can I just confirm?
Hi.
Is my voice clear?
Yeah.
Oh, okay,
Clear.
sure. All right. So how are you guys feeling today?
I'm currently in London, so it's actually 2 a.m. now, but it's all right. Aren't we all night owls as a law student, right? So I think all good. A bit half dead though, so it's okay. I have Shuhan and Stanley with me here.
So let's talk about your mooting journey, right? How long have you guys been actually mooting?
Okay, I think I'll start first since Michelle's counting. I started in the end of 2020. That was during my first year, and that was also when I met Michelle actually. So I started in 2020 when it was International Humanitarian Law, my first moot court competition. I auditioned for that, and luckily I got in. And then after that one was a small competition which was hosted by KPUM in collaboration with Anton and Chen. And then after that, it was subsequently 2 Law Asia competitions and 2 dress-ups for me. Yeah, so I always say that I have 5 experience, but if we count in Anton and Chen, it will be like 6. Yeah. Then Stanley or Michelle?
Sure, I'll go first, then Michelle can be last. I started in my first year as well, after my first year technically. Oh no, during my first year, sorry. There was the BAC Internal Moots. That's my first ever moot competition. And a fun fact is that I didn't actually wanted to participate in that competition voluntarily. So my friends, one of my friends was very interested, and he asked me to join him to audition or to go through the vetting process for that competition. And thankfully enough, I got in. And so that's my first ever moot competition. Then I ventured into more internationalized or bigger competitions like the All Asia competition, where I met Michelle for the first time. That's after my first year. So that's my second one. Then Jessup's with Shuhan, and then one more Law Asia, and ended with Jessup's just recently. So I have 5 or so. Michelle?
It will expose my age. I started way earlier, not way earlier, like at least 1 year earlier. I started in the end of the year 2019. I started similar to Stanley, but a year earlier, our internal moot competition. I don't know about all of you here, but I did moot for the sake of experience, because I felt like if not now, then when? Then I did it. Then surprisingly went to finals, and then started Law Asia as my first external moot competition. Then ever since, it's history lah. It's like quite addictive, I would say. Not everyone thinks so, but you just have the withdrawal syndrome after every competition. You just want to do it again. You just want to do it again. And hence why after Law Asia, I did a KL bar moot competition. It's on constitutional law. Then after KL bar, I did another Law Asia. And then after Law Asia, I did this current Jessup with both Stanley and Shuhuan. Yeah, that's my experience. Back to you, Masri.
All right, thank you so much. So I guess we can start getting into the introduction section. The biggest question everybody has been waiting for: what exactly is mooting? So, any of you want to go first?
I can go first. Okay, then you guys can pick up on. So I think just now there was a very brief introduction as to what mooting really is, and I think it's an apt definition. Essentially, mooting is a simulation of how appellate court hearings would go, I assume. So we're given a moot problem, which is a fictitious problem with opposing parties and legal problems in it. And then we as the counsels are required to do the necessary research, come up with written submissions if your competition requires, and submit orally. Shuhan, Michelle, do you have anything to add?
Oh, okay. So echoing what Stanley has mentioned, if to give you guys a much more like relatable context, I feel like mooting is the closest that you can get to be experiencing what it feels like in practice, because you actually do the real legal research, draft your memorials or written submissions, whatever you call it, and be able to submit in front of judges. If not judges, then lawyers. So it gives you a hint of what it feels like, whether you really like litigation or not. It's really your time to do it now. And I think that's a really good platform for you to experience. Yeah, so that's my definition of mooting. Shuhan?
Yeah, I think the bases are covered by you guys. But I think for external mooting competitions, on average, you'll have about 2 to 3 months to prepare your case. For Jessup, it was longer. It was almost half a year. And so that is the duration of most of the competitions. And basically what you do when you go into the competition is that there will be 2 sides, right? Like what Stanley said. So if you go to a competition like the International Humanitarian Law competition, you'll be in a court called International Criminal Court. So that means that your 2 sides will be prosecutor and defendant. So it goes on like that. So depending on which court are you presenting in, according to that specific competition, you have different sides. And for just it would be claimant and defendant. And so accordingly, with the different background of which court you're appearing in, there will be different court etiquette or different language that you have to use, different jargon that you have to use. So it's quite interesting while you jump around different competitions. But from what I've heard from Umasri, that the current competition that UNISA is holding will be public international law. So I believe that will be International Court of Justice. So yeah, if you want to understand what is mooting, you can probably go to search on YouTube you just type in Moot, and then I think the most famous one that you will see is AIM's Moot Court competition. And then if you go down the comments, you will find there's a timestamp where the mooter actually faints. So that is something fun for you to look for. But other than that, yeah, Moot Court competition videos like that really help you to understand how it goes. And yeah, I think that's basically how you can get started. And maybe you can look at ICJ, International Court of Justice proceedings. They also post some videos so that you can get a feel of how it is really like in real life and then incorporate it into your mood presentation. Yeah, so I think that answers the question. Back to you, Ms. Ray.
Oh, all right. So, can I ask what is the difference between international law competitions and domestic competitions? Are there any differences?
Okay, maybe I can start first. So like a very obvious difference is the sitting, like what Shuhan has mentioned, like it's different court, right? So you have to be aware of that, and with that comes automatically different legal addresses. So for example, like ICJ would be Your Excellencies. If it's like your Malaysian appellate court of appeal, you would say things like my lord, my lady, or even Yang Arif, right? So these are the very clear differences. And maybe the format of the proceedings, it would not differ much. It would still be very formal, very proper. But if you go to international arbitration competition like Law Asia or your NAMCO, it's arbitration. So it's slightly more casual but proper. For example, you do it sitting down, but for court proceedings, you have to stand up. And you don't call the arbitrators Your Honor, Your Excellencies. You just call them by their name, Mr. What or Mr. Arbitrator, Madam Arbitrator. And again, rules technically the same. You have to do your submissions 10 minutes, 20 minutes, and then you have to do rebuttals, sir rebuttals. I believe you guys will be aware if you participate in the UNISA competition. And then probably another difference that I can think of is, of course, the content of law. It depends on which jurisdiction your case is based in, Malaysia, UK, or whatever. And also whether if it's like an international law case, then of course you won't be using your Contracts Act, right? You'll be using like the ICJ statute and the convention treaties and stuff. Yeah, so that's what I can think of. Shuhan, Stanley?
I think I'm less experienced in like domestic court settings, so I think you have covered most of it. Stanley, if you have anything to add.
No, I was about to say that as well.
Yeah.
Because I think we are mainly focused on international arbitration, international law, moot
Michelle's
competitions,
the one with
KLBA
experience
experience.
with- yeah.
So I think that's pretty much everything that that is required to be known.
All right. Okay. So the next question is why should law students join competitions? Why is it important? Any of you want to go?
Shuhan, you want to go first?
Okay, sure. I think I will not spend time saying the obvious is that you're going to have to train your oral advocacy and all that. But I think the main thing that you will notice is that it really deviates from your normal learning pattern in school. Because normally when you go into a lecture for a specific subject, you're going to be fed this case says this, and so the law or principle is like this. But when you go into a moot competition, you're thrown first with a moot problem. And they're not going to give you a document that lists out cases to explain how the law is like, how the principle is like. You're going to have to take initiative to learn about it. And I'm not too sure if UNISA provides public international law as a subject, but for us, at least, we don't take that as a subject. And so it means that we are learning what is public international law from the ground of it. We have to learn the foundation of it ourselves and everything. So I think the best thing that you can take away from a Moot competition is how diverse your research skill sets will be. So it will not just stop from looking for answers in your textbook, or like sometimes you might Google search the answer. But for Moot court competition, there will be a lot of reading of scholar articles that you yourself find. You're going to go through bumps and hurdles where you can't find the answer, but that will eventually lead you to somewhere else as well. And I think for me, at least, I feel that through moot court competitions, I understand the law even deeper than how I do in my typical subjects in school, because we really go from the foundation of it. So I think that probably, well, I don't know yet, I'm not working, but that would probably help us when we are thrown into the actual work field and, we have to pick things up on the get-go. Yeah.
Thank you.
Emily?
Thank you. Stanley, you have
Yeah, I think I would just pick up from where Shuan has left off. So I think she mentioned on how you have a deeper understanding on the law of the law, which I think it's a very true statement, because like when we are in the moot competition, we are very focused on rationales and why the law is such and how we can essentially structure the law into our favor, in our favor. So I think that goes into a very, you will get a very deep understanding of how the law is. Like, it's not just, oh, the statute says this and that is why we are applying it this way. But we are really trying to see what is the statute or what is the particular rule trying to remedy or trying to regulate, and how it would play out differently in our case. And I think as a whole, I think why mooting is important is very subjective. So I mean, I've heard arguments that, I don't want to be a litigator, so mooting is not really that important for me. But I beg to differ, because I think mooting really just gives us the platform to use our cognitive abilities to come up with very creative or even avant-garde arguments that you would not be able to take when it comes to real life court settings. And more importantly, when and where would we be able to submit before reputable lawyers and judges at this stage of our career or our studies, right? So, I mean, we have been very privileged to be able to speak in front of federal court judges, very reputable professors from overseas. And I think that's just an experience of its own kind. Michelle?
Okay, mine is not that deep. Mine is very shallow. As cliche as it sounds, it boosts your confidence. Sounds really cliche, but it really does reflect in your confidence. Even not just like public speaking or when you're speaking to lawyers or judges, like even daily life or even your like I don't know, presentation. You can see yourself speaking much more fluently, more eloquently, and you find that so useful in communicating. Because communication is key whenever and whichever stage that you are, especially if you're working. You're not just talking to your judge, you're talking to your client, you're talking to your employers, you're talking to your peers, right, your opponents. So I think that says a lot, and I can see that really happening, because I'm not so sure about public uni. Probably you guys have mooting as a module or something, but for us in Brickfields Asia College, we have none of that. We just study and then exams, and then off you go to the work environment. And then I have to do the bar, so submission, advocacy, it is a module. And because of mooting, I can see that I'm a few steps ahead of my peers who has never done mooting before. So yeah, mooting is important, guys. It's good that you start now. Yeah.
Thank you so much. So can I ask, to become a mooter, what are the skills that a law student should have? Any of you want to go?
Okay, I can go first. So like whatever that we said just now, the very obvious ones like research skills, your advocacy skills, those are given. But for me, I think there's a key skill of being a good mooter or a good litigator, I would say, is to have a thick skin. Thick skin. You are going to find yourself making so many mistakes, so many, and you will find yourself being embarrassed. Not trying to intimidate any of y'all, but it is something that you have to go through in order to improve. You will find yourself being humiliated in front of very like big individuals like the federal court judges. Like I've mooted in front of Dato Mary Lim before, and then it was embarrassing. Like for example, if they ask a question and I don't know how to answer, this is what we will address later on. But to have thick skin, to know that this is your opportunity to be making mistakes and not when you're actually handling a real life case with someone's life or someone's finance, in your hands. So yeah, make mistakes now, have thick skin. It's okay to be criticized, take them constructively and improve on yourself. And if you think just because you're criticized and then you want to give up, right? I don't think it will get you far. Having very thick skin gets you really far. And I think Shuhan, Stanley, and I, yeah, we're just out there. Okay, come on, humiliate us. We have that kind of mindset. And yeah, that's one characteristics that I can think of.
I think just to save Unisa's mooters, future mooters, right? To not scare you guys away. Honestly, all that I can remember now is all the good memories, lah. Honestly, like I see Michelle is agreeing, and I think Shuhan can agree to that too. It's a testament as to how wonderful mooting can be. As much as we make mistakes, as much as we make mistakes in front of judges, in front of your coach, but at the end, all that you can remember are the good memories. And for me, I think one of the key skills that I think a good mooter should have, I think it's a key skill to being a good mooter, is that just keep being curious, I think. In fact, maybe a little bit even obsessively curious. Because in a moot problem itself, there will be a lot of pit holes, I would say. So we can usually spot a general idea of the obvious topics to consider. Let's say you will have, let's say a contract law problem, you will have a typical problem of your consideration issues, offer acceptance, whatever that is. But there will be usually a well-drafted moot problem will have more nuanced and purportedly neutral facts that may become a problematic, like a problematic point that may assist or supplement your existing arguments, or you have to address it in your arguments itself. So if you are very curious, then you would be able to spot these issues and you can go down the rabbit hole, figure out what this fact is really there for, and then maybe build an argument out of it or address it in your arguments itself to supplement or fortify your arguments. Sean?
Yeah, I think similar to what Stanley said, but before I say my answer, I just want to echo what Stanley said. Most of it is good memories. Okay, but the key word that I think reoccurs for every single competition is that you really need to be resilient, So resilience goes into what Michelle said as well during the actual setting when you're presenting. You cannot give up. Even if the judges push you, have to just try to present your best argument forward. And then most of it also goes into your preparation time. During your preparation, I think I really only learned what true resilience was in my last competition, to be honest, because our coach was a little bit mental, but in a good way. So there will be situations where he presents an argument that he wants to see if it's possible for us to mount. And then the research will go on for hours where we don't find any answers, but we don't give up even there. So I think that is something that I haven't done before Jessups. And that is the differentiating point from how I finally, or we as a team finally showed a result as champion in the last competition. I think that was the biggest differentiation from my previous competitions. So I don't know how in depth it will be for UNISA's internal competition, but once you go external, I think it's very valuable for you to just set down one argument that you want and then go ham with it. Just try your best to find the best case laws or best principles to support you, even if it takes hours. You will find the light at the end of the tunnel. Yeah. So, but most of it is fun because you have your teammates. Yeah. Back to Masri.
All right. Can I ask, is it true that this year's Jessup was your second time participating in the competition?
Yeah, I
Uh,
think, yeah, for Shuan and I, it's indeed our second time. The first time was in 2022, right, where it was done virtually, and we didn't manage to win it. We stopped at semifinals.
So can I ask, what was something that you did when you first joined the competition that was helpful to you in this year's competition?
So sorry, I think I only caught part of the question. You were asking like what did I learn from the last Jessup that helped me in this one, right?
Yeah, yes.
Okay. Oh, definitely it helps a lot. So from the get-go, since we've already joined the first competition, basic things like court etiquette and everything is covered. And we also know what are the usual search engines to use, as in like we would go to ICJ's website to search for cases and stuff like that, but we'll dive deeper in the next question, I believe. Yeah, I think those are the things that I can think of. I don't know, Stanley, is there anything to add?
Yeah, I mean, okay, we probably will touch on this topic later on, but I will just give you a brief overview of what I thought helped me from the first competition in the second competition. So I think one of the biggest advantages for me is that for the first competition, I had absolutely no knowledge of what public international law is. And I had to start with the Jessup guide as to how to research public international law. So that would entail learning the very basic concepts of what public international law is. That would go, what are treaties? What are the importance? Is there a hierarchy between treaties, customary international law, etc.? So having that basic knowledge covered in the very first competition, I think it gives us a certain level of maturity to come up with better reasoned arguments in the second competition. So when I can present an argument, or when my coach suggests something, we can maybe challenge that idea or challenge that proposition with a well reasoned rationale. So I think that comes from a certain level of basic knowledge which we have amassed from the first competition.
Thank you. So, what would you say are some of the common misconceptions that law students might have about mooting?
I think you're breaking off a little bit just now.
Okay. Can you hear me now?
Yeah, okay.
Yeah, okay, all right. So what would you say are some of the misconceptions that law students might have about mooting?
Okay, I think I'll go first for this one. I think the main thing that I realize a lot of freshies will mistake with is that when you go to a court to moot, or like in a mooting competition setting, you're not a debater, you're not a politician. Because most of them will come off really strong. They will speak like they are going for our heads as our opponents, but that is not what judges are looking for. So you just have to remember it's not a debate competition. You're not trying to outshine your opponent in terms of like your confidence. I mean, like in some extent, yes, but not in the way where are you fierce enough or are you loud enough? that is definitely not what would set you apart from your opponent. So I think the one thing that I always try to remember when I'm in a moot court setting is that you are trying to assist the court in understanding your case. You're not trying to win the case by any hooks or by crooks. You're just trying to present your best argument forward in the most persuasive way you can without undermining your opponent's efforts as well, because you have to understand that they have their case built as one, and oftentimes you would understand their position because you're preparing for both sides. So just do your best to present your case, but don't attack your opponents. Don't sound like you're looking down at them, because that actually pulls down your scores. So just remember that, you're not trying to beat your opponent, you're trying to present best case forward. That's all. Yeah. And
Okay.
Michelle?
I can go first. I agree with Shuhan so much. That you not just have to. Okay, I think the misconception here is focusing on yourself is enough. I get it, because you want to be a better mooter, just so your team, have a better advocate per se. But that is definitely not enough, because somehow our competitive mindset will also think that I have to be better than my co-counsel, something like that. But that's not the case, because the true conception, it shouldn't be a misconception, okay, is that your team is as strong as your weakest link, right? So if you are brilliant, you can answer all the judges' question, but your partner can't seem to do that, that will outshine whatever performance that you just gave. So at that point in time, you have to focus on your team, not just yourself. Despite focusing on yourself is important. That's one thing. And the second thing is, okay, this sounds really bad, but take it with a pinch of salt. It's being a good mooter is purely based on hard work. I don't think so. Yes, hard work is of utmost importance. Okay, guys, please put in the hard work. But I do think to go very far, there's some kind of luck involved, right? Luck means that competition strategy, who you're going up against, your mood for the day, right? Whether touch wood you're sick or you're not sick, all this comes to play, right? So these little things. So as much as you want to put in a hard work, take care of yourself to make sure that the stars are aligned for you and your team. And what else? Oh, another misconception. Sounds really bad also. I'm like the worst speaker here. Okay, the misconception is you have to be good in mooting for you to become a good litigator. Not necessarily. It helps a lot, but there are also a lot of amazing litigators out there who has never done moot before. Just because I say this doesn't mean you have to forfeit your opportunity to participate in your internal moots competition right now. Just go with it, because whatever pros that we have mentioned applies still. Yeah, that's for me. Stanley?
Okay, I'm struggling to find. Now that you guys say this, I actually realized, there are really like quite a bit of misconceptions about mootings. I couldn't really think of one, but one I can think of at the spot, or I can say off the cuff is, there's a misconception that you have to be a good speaker. Like fundamentally, you have to be able to speak well in order to do well in mooting. Which, to a certain extent, I think there is some truthfulness in it. But I think having a good grasp of your language and having a good grasp of how fluent you can speak doesn't really determine how well or how far you can go in mooting. And that really ties back to whatever Michelle and Shuwan has said. It goes to how you strategize, your luck for that competition. But certainly, if you have a certain level of proficiency in English speaking, and a wide range of vocabularies or lexicon that is available at your disposal, then that certainly plays to your strength. But all I'm trying to say is that even if you don't think you can speak well, be it a confidence issue, be it a actual language issue, I think that can be overcome by sheer hard work, right? And that I'm not trying to contradict my co-panelists here, but yeah, so I think hard work really plays. I still think hard work really plays a very big portion of your success. Maybe you hear that saying that 99% is hard work, but to win you need that 1% of luck and strategy. So I think Michelle is really talking about that 1% or that 5-10% even. So I think that wraps up our discussion on this question itself.
Thank you so much. So I guess we can move on to the researching and preparing for a competition. What are some of the resources, such as the database, online libraries that you use to research on a specific issue? Any of you would like to first?
Okay, I'll go first. Sorry, you were breaking a little. So I think the key question was what search engines or resources do we go from, right? Okay, so for different settings, you will have different search engines to look for. So for example, if it was IHL, it would be, you wouldn't use the ICJ database, you would use the ICC database, the criminal court database, and also ICRC. So it depends, but I think to cater it to what UNISA's competition is going to be, I believe the one that you will use will be ICJ. So ICJ list of cases, when you Google that, the first thing that comes up is where you can find all the case laws, and you can use your search engine to, prioritize certain keywords that you want to look for in your cases and things like that. And then the newest search engine that I realized or I discovered in the recent competition is World Courts. So that covers every single international court in the world that you can find. So just type in World Courts, literally, the search engine, and it works the same. You can prioritize certain keywords and things like that. And then UN Digital Library is what we use to find UN documents. So that will cover things like Security Council resolutions, things like that, which can help you to build your case. And then other than that, when you come to scholar articles, at least for us, because Jessup provided us with like an account for Oxford Public International Law. So from there, we could use Oxford PIL as our search engine, but sometimes some articles we cannot access as well. We have no idea why. And then there's Hein Online, HEIN, Hein Online. Most of the articles we can access through our school accounts, but I'm not too sure how UNISA's student account would work. But then if you really hit the blog and the article or anything that you want to find, you cannot access, right? And you have the DOI link. So it will look something like HTTPS, and then there will be a lot of numbers. Just go to Sci-Hub. Sally is laughing because this recent hack we found. So it's SCI Hub, HUB. Go to Sci-Hub, paste that DOI link. 80% of the time, the article will come up, but sometimes it doesn't. But you can try your luck. So
Let's pray that this recording doesn't get public, no?
I know. Don't simply share. Later they, shut down Sci-Hub, like how they did with Z Library. Yeah. So I think that's it for me. If you guys have anything to add.
Okay, that whatever Shuhan said is very, very comprehensive for international law, probably international law. But again, for different competitions, different search engines, different database applies. So I think most of you guys would know if it's a Malaysian court case, your CLJ, your LexisNexis will apply. And if it's like a UK jurisdiction kind of case, Lexis still applies. But what I've discovered when I started in London here is that they rarely use Lexis. They use Westlaw a little bit more. And I do think that Westlaw is a little bit more comprehensive in terms of UK cases. Yeah, and again, I always give like the worst and best tips. If you are just starting off, it's okay to use Google just to have a brief idea of what's going on. You should never cite Google authorities. You should only give you an idea, oh, offer and acceptance work this way, but you have to see lah. Maybe it is quite useful, Google. Sometimes someone just like randomly post an article that they have footnotes, right? Then from those footnotes, you can venture, like maybe they cite this article, and then when you go into this article by a certain professor, the professor would have cited an enactment or a case. So facilitate it correctly, not for you to cite Google, but it's perfectly fine for you to go on Google and type the broad issues that you want to search on. Yeah. That's the first step. Yeah, but if it just so happens that you already know what issues is a breach of contract, then you can just go on Lexis CLJ or breach of contract, right? Then you don't need to go Google. Yeah, that's from me.
Yeah, I think, my co-panelists are have provided very comprehensive advices on how to start off your research. And I think I really agree with the Google search approach, when you're first starting out. And I think that really gives you a good understanding or broad understanding of what you are going to find or what you may need to find, right? You may even find things that, you don't think is an issue from the outset. So let's say you were trying to find issues about breach of contract. But as you read through maybe very brief, those kind of broad understanding of what breach of contract entails, then you realize, maybe there are some issues in this portion, remedies, rescission, what can you do there? So those are the things that you can do. And probably one last source that I would add on would be Google Scholar, where you can find a broad list of scholarly articles, which will also probably link you back to resources stated by Shuhan, like Hein Online, JS Store, whatever that is. But yeah, I think Google Scholar has a good grasp, more on US law though. But yeah, it has quite a good amount of scholarly articles you can consider. Mashri, back to you.
Right. Thank you. So how do you incorporate, through your research, and you find these legal sources and stuff like that? How do you incorporate that into your legal arguments?
Okay, I think I will start off with the ICJ statute. But the details of it, I think my co-panelists can expand on. So if you search up ICJ statute, the statute for the International Court of Justice, and you scroll down to Article 38, right, there will be a list of international law sources that we're laughing because it's a basic thing that we always go back to. So Article 38, sub 1 specifically will list down 4 sources of international law. From there, it means that you will see scholars often cited as the prioritization, or how to say, the authoritativeness of the sources is listed as such. So A will be the most important until D. So it means that in your legal arguments, you should prioritize whatever that you can find in A first, which would be case law. And then you slowly work down the hierarchy. Sorry, A is case law. A is not case law. A is international conventions. But like, you can just look at it and then just make sure that whatever that you're citing, try your best to work up the hierarchy. And if you really cannot, work to the bottom. And yeah, that's the technical side of it. But yeah, Stanley and Michelle, you guys can expand on the details.
Then we'll go next. Just to preface what Shuan has said a little bit, I think generally when we are talking about incorporation of legal sources into our arguments, I think the general stuff that we learn in law school would apply. So I'm referring to like the IRAC method, issue, rule, application, conclusion type of structure would help you incorporate those legal sources into your arguments. But as to which legal source to incorporate first, then sure, follow the authoritativeness as mentioned by Shuhan earlier. Another thing that I would probably recommend you do is, yeah, I mean the general stuff in law school, like distinguishing cases, pointing out differences, drawing analogies, that all applies to how you structure your legal arguments. So, Michelle, you have anything to add on?
Okay, so for the participants here who have actually read through the ICJ statute would understand what Shu Huan was saying, and you have to look at it if it's a public international law moot problem. But generally, in all types of moots, how you incorporate a certain authority to your legal arguments, there are two ways to go about it, I think. Firstly, if you don't know how to go about it, you always go to, for example, you are in the ICJ, you go ICJ statute first. Then, for example, you know it's at times of war, you will go to Geneva. Oh, just me. Must be you're like there are a little bit voices crackling. Okay, it's okay. Don't worry. Yeah. So if you know your moot problem is in, for example, in times of war, then you know like Geneva Convention will apply. Then you read through Geneva Convention to see which provision kind of like applies to our facts, which we did. We actually go through every provision of Geneva Conventions or any treaties that you can ever think of to see how it applies to the case. So it's from the law transfer to become legal arguments. The second method is the other way around. So sometimes when you have a certain level of legal maturity, when you look at a moot problem, you will know for sure it's a breach of contract or there's a remoteness of damage that involves in this case. Then from that particular issue, you have identified the legal argument first. Then you go and search for relevant authorities to support that argument. So it can be two ways, from your law to become legal arguments, but it can also be you forming the legal arguments first, despite it being correct or wrong. Then you go and do your research to find arguments, to find authorities to support, or you might find authorities that don't support, which helps your teammate if they're doing the other side. Yeah, so that's how I think you should incorporate authorities lah. Masri?
Okay, thank you. By the way, is my voice clear? All right, okay. So how do you stay up to date with the developments in international law?
I'll go first.
And you?
On this. Yeah. I think there's not a structured way to do so. But what I do is that I think we will follow certain social media accounts that talks about international law. For example, maybe ICJ has an account in LinkedIn, and they will make press releases regarding latest cases. For example, I think they had a case that my coach cited or sent to us, the Azerbaijan case or interim proceedings. So that he got that from ICJ, from the LinkedIn ICJ account. So I think that's one way that you can get on top of developments in international law. Other than that, maybe even normal accounts that talks about international affairs would be suitable. Maybe like normal CNN or whatever reputable sources that may provide you with a certain level of knowledge regarding international affairs would be a good choice. What do you guys think?
Yeah. Okay. Yeah, I think my answer is like the same with Stanley, but just to reassure everyone, luckily, international law doesn't develop as fast as you would think. They're often really slow. So, and it's slow for a good reason, of course, because it has a huge impact. So the general developments you will always already find during your normal preparation in scholar articles. They often goes to the very beginning of how the law was until now. So other than that, very new developments, they often would invite criticisms as well. So that means that even after, if like what Stanley said, you caught upon a new case that speaks about a new aspect of a standing principle, you still have to see if people have criticized it and things like that, which will help reach like either side of your cases lah. So yeah, I think bottom line, international law doesn't develop really fast. And if it does develop, it invites criticism. So yeah, that's it. Michelle?
Yeah, they've mentioned everything. But yeah, the most direct way is look at the news. Even if you don't read the newspaper, you don't watch the major bulletins on the TV, don't worry. When there's an international or ICJ case, it will be so major that you cannot ignore. For instance, like everyone knows about the Russian-Ukrainian conflict. Like even if you don't read the news, you will know about it, right? Then if you think that somehow it kind of relates to your case, then go read about it. And you also find that different organizations, student associations from all around the world, they will organize some sort of talk to a certain issue that you will find relevant. For instance, our team, right? Our coach will send us random links from LinkedIn saying that, oh my God, there's a webinar, there's a talk here. Do you want to join? It can be from like different countries, like German. They will speak certain accents that we'll never understand. But yeah, it's fun. You see different perspectives, and usually they invite like very known lawyers, professors. Yeah. So LinkedIn is a very useful place, and the news. Yeah, that's from me.
Thank you. All right. So when you're preparing for a moot competition, right? How do you work as a team? What are some of the strategies that you can use to prepare for the moot competition?
Michelle, you want to go first since you started first?
Oh, it depends on the dynamics of the team. Because I've been in different team combinations before with different people. Some people are stronger in certain aspects than the other. So, for instance, previously if you're saying research, then I have done, I think, 2 different ways of research. Number one is for if your moot problem has 4 issues, you handle 2 issues, then your partner handles the other 2 issues, which I think a lot of you would opt for because it kind of lessen the burden. You just handle 2 issues. I don't need to care about what the other 2 issues like really talk about. Fast, but not really effective. So what we did differently this Jessup is that all of us focus on one issue. And then after finishing that issue, then we move to the other, which I think is very useful because number one, more manpower in one issue. You get a lot more authorities read up. And at the same time, you also have to understand in moot, you have to do rebuttals and rebuttals, including rebutting for your partner for their issues. You cannot go into the competition not knowing what their issues are all about and expecting to rebut on the opponent's point with regard to those issues. So if all of you focus on one issue, research everything possible for that issue, you have already have a grasp of all the relevant authorities, that even if you're not handling those issues in the competition itself, you will still have an idea of what those issues are about, and you can make more effective and efficient rebuttals and rebuttals. You don't want to be in a position where you're in the competition and your partner is writing word for you in terms of rebuttals. I have experienced that before. Stanley and I, when we were in Law Asia, because we focus on our own issues, we don't know. We only know briefly of what each other's arguments, but we don't know the in-depth arguments. So we open up a Google Doc. It's an e-moot competition, by the way. Open up a Google Doc. Then we type word for word okay, whilst the other is something, okay, then okay, literally word for word. So that person will have to read the rebuttals like that. But normally, judges wouldn't ask any questions during rebuttals. But what if they do? They just want to be annoying and they want to ask you questions in your rebuttals. Then, you're reading word for word. You don't know how to answer. You don't want to be in that position. But again, it depends on the dynamics. But if you think handling your own issues it works better for you, go ahead. But that's what we found most useful is all of us handling one issue by issue together. Yeah, that's for me.
So I think we have to caveat that by saying that it takes a lot more of your time, of the whole team's time, because yeah, I mean it's just a lot more work to do when you have 4 people on one issue, right? You have a significant amount of input because initially, let's say you're taking like one person, you're doing only 2 issues or 1 issue by yourself, then there will be only 1 input essentially, right? You will be the only input into structuring that argument, bar the participation of your coach in that structuring exercise. But in this case, we have the whole team in it, 5 members plus the coach. So yeah, it took us a lot of time to just structure our arguments. I'm not talking about putting it into the written submissions or forming our oral submissions. Just structuring we have a structure for our legal arguments, and that took a month or so, right? Yeah, just researching what we want and all that. So I think that took a lot of time, but like Michelle said, it pays off in that we are very, very well versed with all the issues. In fact, I think in rebuttals and rebuttals, which Ashwan and I did, we were able to come up with very, very effective, or at least I like to think so, something that is very effective. And we were able to link issues or contradictory points between, let's say, the first issue and the 4th issue, which is something that we won't be able to do had we followed the old approach that Michelle and I did for Law Asia. And yeah, I think team camaraderie is very important. So I think you can sense the dynamics or the chemistry between the 3 of us is just very good, or at least I like to think so once again. And yeah, we have become very, very good, very, very close friends because of Moot competition. And I think that really helps because imagine spending 6 months of your time with like 5 people, right? If you can't gel well or you can't vibe with them, how would you work well with them, right? That, to work well with your team presupposes a good relationship or a good friendship between the team members. So I think aside from skill specific dynamics though, like for example, I think Michelle and I make a very good team. Like she's more articulate, I'm more calm. So there is a contrast between the 2 speakers. That's skill specific type of dynamics. But I think chemistry wise, I think we have very good chemistry as well. Like she would know when I need help on certain stuff, and she would provide that assistance. Same goes for me. So I think all that really plays into how well your team perform. It's not just like what Michelle said once again, right? You cannot just think about yourself, right? Certain parts of the competition you have to step down, you have to step up, and that all depends on how well you gel with your whole team. And you have to make that decisions based on those relationships. Sean?
Yeah, before I answer, I just want to ask either Umasri or anyone from the organizing team. So for your upcoming competition, how many people do you have in a team? And how long do you have to prepare for the competition?
So we will have 2 to 4 participants per team, and we have roughly around 2 months to prepare.
Okay, 2 months is a good 2 months is a good period because oftentimes internal competitions they just take like 1 month, 3 weeks, and you'll die. 2 to 4 teammates. Okay, so I think from all of the advice I was given previously, it would really, really work the best when you go into external competition. You have a long time frame to prepare. You have a lot of teammates. But if you're really working with like 2 manpower, and if it happens to be 4 issues, I think then for 2 months, it wouldn't be wise for everyone to focus on each issue, but to split it up. But like what Michelle said, it will not work well if you don't understand what your co-agent is saying. So at least understand all of the issues by the end of the preparation time. But if you have 4 teammates and 4 issues, I think what Michelle and Stanley has advised just now would work really well. Just go into each of the issue together, research together, because that is how you also can avoid mistakes. Like during your presentation, you say things that will contradict what your co-agent will say later or what your co-agent has said earlier. So things like that will be avoided once you really cover all bases for all issues. And in terms of dynamics and all that, I think joining internal mood competitions, you often just find your friends. So I would assume that you have a good dynamic with that person already. But once you get into an external mood competition, I'm pretty sure you guys will have a coach. So a lot of things will be controlled by the coach, I believe. They will have the say as to who will do what. But internally, I think most importantly, like what Stanley said, the team cohesion is really important. So make sure that during your meetings or during your preparation times, you don't just like go into the meeting, research, discuss, and then, okay, thank you, meeting adjourned, and then you just leave. And then you don't know bad shit about your teammates, because I think that is really what pulls a team together once you have a personal touch with each other. And I know like it's a really like mushy topic, but it really does, at least in my opinion, it's really important for team cohesion that you really understand and know each other as friends. But once again, internal competition, I would assume you're signing up with a friend, so that should be a problem. Yeah, so that's all from me.
Like a small add up from whatever we've said just now. What I think works really effective is having a strict timeline. It will make you anxious. It will give you, it will make you like nervous. Oh my God, I only have 1 week left for certain issues. But sometimes you don't even have a week, to research. So if you have a lot of manpower in one issue, I think what we have done previously is when we started brainstorming is legit. One day we brainstorm, next day we have to give the outcome for our research, or maybe at most a few days our coach will want to see it. But it's because of that we are on track, or at least I think we are. Yeah. But having a strict timeline is very important. You don't want to be slacking, thinking that it's just 4 issues, there's 2 months, we have plenty of time. That's not the case. Because throughout your journey, when you're researching, you will find more and more issues, discover more and more stuff that can be relevant, possibly relevant. Yeah, so you don't want to rush. We have rushed so much before. I think Stanley would know that one day before the competition, we realized something that we didn't discover, and that everything has to be done one night prior to the competition, which is crazy. Stanley can say something.
Yeah. I remember that law is I specifically remember it's a procedural issue where, because like in arbitration we need to determine the governing law, right? And then we realized that the governing law may not be what we thought it was. It may be another governing law. So yeah, we had to come up with all the amendments in one night. And I think just to add up on what Michelle said, I think one way to really strengthen your team camaraderie or like the whole dynamics would be to meet physically and train physically. I think that is very, very important. Somehow I actually wonder how we got close, Michelle, even though we did the whole thing online. Somehow I wonder. But
I think you just automatically become close when you're in crisis,
yeah.
You only have each other.
Correct. We're in the same boat and the boat is sinking. Yeah, but I think meeting physically would really, really help. Like, even for dress-ups, I think even though we went in for the recent dress-ups, we went into the competition with very good, we have very good relationships between the 3 of us. and our coach, which I really respect a lot and treat him as a friend now, that I can proudly call him as a friend. But yeah, on that basis, we have 2 additional members, new members that we have never met before. And I think it's because of physical meetings. I think like the first month, if you guys realize, I think we are more, I mean, at least with Kimberly and Yongzhen, our team members, we're a little bit more distant to a certain extent, right? To a certain extent. But I think once we started meeting physically for the memorial drafting process to brainstorm, then I think, we are more united and everything can be done quicker, more united. And that really builds up to what we have now.
All right. Do you guys have any more time management tips?
Time management as in like the competition preparation or during the oral submissions itself?
For the preparation.
Though I don't think we are in a very good position
Yeah,
to do that
correct.
because we were when we participate in moots, we get really obsessive. We work day and night for it. Not advisable in terms of your academics, right? So you should allocate time for studies, go to class, and your extra time, supposedly extra time to do your moot, but that's
Utopian
not
lah.
our case.
Utopian.
No. Yeah, but that's not us. When we do moots, right, even when we sleep, we will dream about it. So that just goes to show how crazy a moot can go. But it's not like crazy in a sense where you deprive yourself of your mental health, right? Maybe you would need to sacrifice a bit of your social life, if not all of your social life. But it's up to you to choose. Perfectly fine for you to still go out and have a drink. But that's not really appropriate. Just go out and hang out with friends. Yeah, you can still do that, but maybe you would have sacrificed like another aspect, for example, sleep. Right. So the craziest that I've been is for my KL bar moot competitions, because I have a coach which is of a different style. We have to work 24 hours for the moot, and then I have not gone to class for at least 2 months. The only reason why I can do this is because for us, right, attendance is not really like compulsory. We will not be penalized if we not go to class, but I think you guys are. So go to class, okay? It's not. We would not encourage you to skip class for moot, because after that we suffer lah. But what I'm trying to convey is that you will invest a lot of your time and energy into moot. So time management, very subjective.
Yeah, I think okay, for this competition, right, the recent Jessup competition, we started off with a very strict schedule, which I think it's very heavy already, which we will train 4 days, 4 nights a week from the get-go. But we actually stick to it. We adhered to it. We didn't really slack off, right, per se. But we realized that the way we are operating, I mean, the schedule doesn't support the way we are operating, because we're trying to cover such a large ground of research, and that really requires a lot more of time. So what happened was, from the 4 days, we added 5 days. Eventually, it was daily. And then I think the memorial drafting period was the most, was the toughest. Yeah, you see, Shuan is laughing. Was the toughest, what do you call that, situation I've been in.
We had sleepovers lah.
Yeah, we will sacrifice. Yeah, define sleepover without sleep, right? Yeah, we'll sacrifice sleep. Social circle is non-existent from the from the period we decided to participate in the recent dress ups. So that was like a lost cause lah. Social activities was a lost cause already. And sleep was later also sacrificed. But well, I mean, I think it all paid off lah. So looking back once again, I think it's all the good memories that counts.
Yeah.
Yeah. So I mean,
think,
sure, go.
Okay, to add on top of that, I think when you talk about time management, right, like what Michelle said, it's very subjective. It means that it's going to be very different for everyone in your team as well, their expectations, I mean. So if you don't manage that expectations in the beginning, there's going to be a lot of friction. So I think the most important thing for time management is to set it straight in the beginning, or at least in the beginning of every time you want to change up your schedule, because that's what happened for us. So just make sure that everyone in your team is on the same page, because if you don't do that, eventually you will find only one or two people that are really putting in hours, and the other ones are not really up for it. And this really didn't happen at all for our recent ones because of the expectation setting that we always make sure to do. So because you have classes to attend, which for you is compulsory, and you have other things probably to juggle as well, everyone's going to have different commitment levels that they can provide to the competition. So in that expectation setting thing, you just have to take into account of what is going on in everyone's life. And then from there, work forward. And then make sure that no one gets left behind in the progress and things like that. So actually, that's a good question. Time management is really important. Yeah. But yeah, if you can, get sleep, do sleepovers and all that, that's going to help exponentially. But yeah, I think that's all from us.
Though I think for internal moods,
Yeah.
that I doubt that is needed.
It's also not as worth it, I think, because external moods like just up really. You just have to work your ass off. But yeah, the expectations. Yeah.
Right. So let's move into presenting oral arguments. So typically, what is the evaluation criteria judges to evaluate your oral presentation?
Okay, perhaps I can go first. Again, differs on what kind of judge you're getting. So again, I will broadly categorize them to two types of judges. First type, prepared. Second type, not prepared. So when you get a judge that's prepared, how define prepare? They will read through your mood problem. They would have the knowledge, the relevant knowledge for the mood problem. They have even gone their way to do some research for the mood problem. At this point in time, you will have to be really prepared. So just because you have good English, good advocacy skills, don't impress this type of judges already, because they want to see real content. They want to see that you actually understand the law and the application of it. So these judges will look at your content, your persuasiveness, your ability to address their concerns or questions. So that's for those type of judges. The second type of judges, not prepared. I'm not giving them, not shedding a bad light on them. The only reason that they are not prepared is because they have really, really busy schedule. They really have no time to look through your mood problem. But again, you cannot see it as their fault. It's really your responsibility to assist a judge, despite them knowing nothing of your mood problem. You have to guide them, treat them as babies, step by step, telling them what the mood problem is all about, what's the relevant issue. So at that point in time, those type of judges will look at how well you actually guide them, and at the end of the day, how you make them understand the case, how you persuade them. Probably they don't know as in-depth as those judges who prepared. They will look at your demeanor, your advocacy skills, how fluent you speak, right? So you have to excel in those. But you will never know what type of judges you're actually getting during the competition. So it's only wise for you to take care of each aspect of mooting. So you can't just focus on content but have bad English, worse grammar and stuff. But you also cannot have the most flowery language but have no content, cannot answer questions, right? So I think that's from me. Johan, Stanley?
Sean, you go first? Okay.
Sure. I have a basic score sheet with me from a past competition. So it's actually like, I don't think there's a lot of difference between competitions and the different score sheets because I've seen different versions, but they always cover the same basis. So there will be 5 categories. So first is knowledge of the law, and then questions and answers, knowledge of the facts, your style, poise, or demeanor, and then your organization and time management. So I'll go through all of them briefly. So the first one, knowledge of the law, is going to be when they ask you questions about the legal argument that you're presenting. Then probably they will ask you about an opposing view that probably because some criticism has been raised by scholars on this point of law. That will really go into your part of the, how they score you on that category itself. But even in your own presentation argument itself, if you don't mount enough legal authorities to back your arguments, you will get really low scores for the category knowledge of the law. And then next will be questions and answers. This will be when they judge to see how quick can you think on your feet, how structured can your answer be in that very short time frame that they provide you to answer. And yeah, just it really intertwines between the categories, but for Q&As in specific, you have to make sure that you actually answers what the judges ask, which sounds really simple, but it's sometimes it's not, because they might ask you a question that took 10 seconds or like 5 seconds, and then it just zoom past like that. And then it will leave you hanging sometimes if you don't listen carefully that, wait, what are they asking actually? So this goes with practice. As time goes by, you'll get better at it. But just remember from the get-go, from the very beginning, that when judges ask you questions, it's not as simple as you would think. You have to really understand where are they coming from when they ask that question for you to answer what they want to hear. And then next is knowledge of the facts. So this will go into when you present your arguments, do you use enough of what the facts provide? So there will be, I think earlier on Stanley has mentioned this, that you will find things in the moot question that will help your case. So all those bits and pieces, all those nuggets, you have to make sure to include in your legal arguments, because if not, then you will lose your score on this. And then style, poise, and demeanor, well, this is very subjective lah. And I think I always cut back in advising on style because everyone has their own. But tying back to what I said very, very earlier on, just make sure that your tone is assisting the court, not attacking your opponent, and you're good to go. Yeah. And then last is time management. Well, it's a little hard sometimes, but it really depends on what bench you get. So there are hot benches and cold benches, what we call them. Hot benches will ask you a question every 2 minutes. Cold benches will probably ask you 2 questions throughout the whole presentation, or even 1 or none. So it's a really unpredictable thing. And I think I've spoke a lot, so I think I'll leave this detail to Stanley. So yes, then you can add on.
Yeah, so I think my co-panelist, Michelle, has provided you guys with a very subjective evaluation criteria on what you should do when you face different types of judges. And then Shuhan has provided an objective objective evaluation criteria as to what a judge would look for when they are, sitting as a judge in a moot competition. From the subjective point of view, I think whatever Michelle said is very apt, and then I totally agree with all those explanations. for the objective criteria, I would just add a few things on top of what Shuhan has said. Knowledge of law as the first category. I think one of the points that Shuhan said was to mount arguments with sufficient legal authorities. And I think that is a very apt elaboration once again. But I would tie that to Michelle's point of view, that when you are faced with a judge that is not as prepared or not as well versed with the subject of law, because sometimes judges will be judging competitions that is not in their alley, right? Let's say they are a corporate and merger type of corporate lawyer, and they're asked to judge competitions like Jessup's, for example. So PIL isn't really their cup of tea, right? So we can't really blame them. We can't really fault them for not knowing much about PIL because that's simply not their forte. So in that case, if you are too heavily law focused, right, you cite a lot of cases without going in depth as to what those cases or how those cases would help your case, then it would play out differently. So I think when we say sufficient legal authority is very subjective, right? Sometimes 3 may be considered sufficient. Sometimes 7 7 cases may be considered sufficient. So it really depends on how you structure your legal arguments, right? And I would just add a little bit on time management. Yeah, so if you get regardless whether you get a cold or hot bench, I think it's very, very important for us to end our oral submissions within the time. I think that's something that my coach really, really emphasized. Our coach really, really emphasized in the previous competition, and we got reamed for exceeding time multiple times. Shuan, I think you would be, yeah, okay. But regardless, I think it's very important for us to keep within the time frame. So let's say you are given 21 minutes to finish up your submissions, then finish it up within that time frame. Even though, let's say you are faced with a lot of questions, you don't have enough time to really finish all the arguments that you prepared, it's okay. Just finish it within that 21 minutes, whatever that you can. Present your most powerful or your strongest arguments, then end it nice, you know? Yeah, that's with regard to time management, knowledge of law. What else do I have to add? Yeah, I think that's pretty much it for what a judge would look for when it comes to moot competitions.
Do you have any tips on how to structure your oral arguments?
Okay, I'll start with a brief introduction, then you guys can pick on that. I think most importantly, the common thread that every judge would say is to provide a very good roadmap or flag posting, right? As to the exact structure itself, you know, the typical, like I said, the typical stuff that we learn in law school, issue, rule, application, those things would apply, right? But it is how you show or how you explain to the judges that matters most, right? You can structure your arguments in the IREC method, but if you don't tell them this is what I'm doing, then they wouldn't know, right? Because when we are speaking, more often than not, everything seems to be lumped together, right? We can't really differentiate, oh, you are trying to elaborate on the issue. You're trying to tell us what the applicable law is, right? So it's very important for you to highlight exactly, say, let's say, I have 2 submissions to make regarding this ground. The first submission pertains to this issue, and then you start with the rule. How would you apply the law to the rule and why you should listen to me or decide in my favor, right? So that's I think that's a good starting point. Michelle?
Okay. My point of view for this question is how to structure. Okay, taking into account Stanley's advice, I think no matter how detailed or how brilliant your structure is, it wouldn't take you far if you cannot be versatile or flexible. You will find yourself having, wow, this structure, if I follow it, then definitely it will be an amazing submission. Then you'll find yourself in a situation where the judge asks you so many questions. You're in issue 1, but they ask you questions on your issue 3. Then it's up for you to be flexible and be able to jump here and there. And you find yourself, oh, the structure is no longer in use. Then you cannot be so stagnant and stick to your structure just because you want to. Because at the end of the day, the judge are the ones who will be marking you. You want to be assisting them. You cannot say things like, or when they ask you issue questions on your third argument, then you say, oh, I'll be addressing Your Excellency's concern later on in my submissions, right? Because that is the question that's on top of their head and they want it to be answered. So it will only be right for you to address them despite it being your submissions later on, right? And again, it's up to you to engage with the judge and see whether you want to further elaborate on that point, or you want to go back, maneuver back to your point, picking up from where you left off, right? So you can have a good structure, yes, but it will only have the best effect if you are able to be flexible, right? Yeah, that's from me. Shuhan?
Yeah, I think in a similar vein from what Michelle said, to structure your arguments well means that you know how to prioritize your arguments. So oftentimes, let's say you have 2 issues on your hands. Under each issue, you have, let's say 3 arguments. So you have 6 arguments in total. Under each argument, you have probably maybe 3 legal authorities. So you can see how the branches start to grow from there. And then like what Michelle said just now, the judges are going to ask you about this and that, and you're going to be thrown left and right. And you have to make sure that you don't really lose track of where you were. So a thing that helped us in the recent one is to make a checklist of your arguments so that you know exactly what you have presented, what you have not, where you should go back to. But I think the most basic thing for you to take note of before the very advanced levels where you get really used to mooting is that know that you don't have to present every single thing you have on your hands. Just present the one that will help your case the best. If you have time, then you elaborate. But sometimes even elaborating doesn't help. So for example, if you're presenting on issue 1, the first branch of issue 1, you can see that the judges are with you already after your first argument, and you see your time is running. You just move to the next one without having to elaborate on maybe your 2 backup points. Because at that point of time, it wouldn't be a wise use of your time. So just know that you can have multiple arguments under one arm, but you don't have to present all. You have to know where you are when you're presenting before, when judges ask you questions, so you know where to go back to. And then just know that sometimes you really have to sacrifice a whole arm of argument, and that's okay. Just make sure that you don't leave maybe issue 2 completely not presented. That's really bad on you. So just, I think it goes really well after you practice a lot of times. Practice with your teammates also, like Q&As and all that. Make your teammates ask you a lot of questions so that you know what to do when it happens in the actual setting. You get thrown a lot of questions and you don't know how to move on and how to lead the judges back to your presentation. I think that's a really important part of structuring your arguments. Yeah. Yeah, I think that's all. Masri?
So do you have any more tips on how to handle challenging questions from the judges? Any
I
of you?
want to. Sorry, Masri.
No, go ahead.
The quick answer to that is never put yourself in that situation. And the one word answer to how to not put yourself in that situation is to prepare. Because if you are so prepared, you have read everything that's possible, you would definitely have an answer to the question that the judges are asking. right? So if you don't prepare, you're slacking, then of course you don't know the relevant authorities, the relevant arguments, the facts that helps address the judge's concern. So you have to get the groundwork done. There's no shortcut for this in addressing challenging judges' question. And secondly, I echo what Shu Huan has mentioned just now. Have your teammates ask you so many questions, so many, that you would be able to then pre-prepare your answer, because more often than not, the judges will ask the very blinding concerns, and you would have already prepared because your teammate would have asked you that. You will reach a point in time where the questions will be the same, because all of us are discussing one problem together. We know what the loopholes are. So that's just it. So what I suggest you can do is maybe to get what we call guest judges. So guest judges is not you going and invite judges lah. They're really busy. So you can get seniors to hear you out, senior mooters, or if you have happened to intern in a law firm before, you can kind of contact that specific lawyer, or can you hear my team out? So from different people's perspective, they will ask you different questions. Maybe you can even ask your friend who has never read the Moot problem, has never done Moot before, listen to you, and then they will ask you very shallow questions. But those are the questions that would be most probably be asked by judges who has never prepared for that Moot problem before. And it's only going to be effective for you to practice so many rounds, be asked so many questions, that you will be able to handle any judge's questions. Again, if you happen to get a question that you have never heard before, probably it's because they worded it differently. You can clarify with the judges what they're asking in a very polite manner. Or if you cannot catch the question, it is perfectly fine for you to ask them to repeat, but don't do that every question. This shows that you're not attentive. But if it gets to a point where you really need clarification, then seek those clarifications. Yeah, that's from me.
Yeah, I think the participants would realize that we always try to give advice that are not so cliche, right? We try to really zoom in into different aspects of mooting that is not usually discussed in other forums or talks. But I think this one, I really agree with Michelle, because there was just no shortcuts to this, right? And to, like what Michelle said once again, if you prepared well, right, then it doesn't, correct. You may face questions that you have never heard before, but mostly it's the same questions worded in different ways, like what Michelle said. So I think one way, instead of just what we mean by preparation, would be to practice how you formulate those answers, right? So let's say you get a question on a specific topic, regardless of how it's formulated or how it's presented to you, right? You have a specific, what do you call that, breakdown on how you will tackle those kind of questions. And practice retrieving that information from your brain, because your brain, biologically, it's like a dome or a vault of informations with short-term and long-term memories. Some of the things you already know, but it's just that you don't practice retrieving those information. So when you are put on that spot, you are panicking, you are sweating, you just can't retrieve that information quick enough. But you have that information in the back of your mind. So one way we can prepare is to practice how you retrieve these informations and how you put it into words when faced with a particular question, regardless whether it's challenging or not. So I think that's really my view, that there's no shortcut to this. Sean?
Yeah, I agree. Like there really isn't another way. You just have to do it a lot of times until you get it. But when you're put on the spot, in the setting itself, I think it's really easy for you to lose your footing and panic, like what Stanley said. So small things to remember during your presentation and when the judges ask you questions is that you can take 1 second before you answer. You don't have to immediately, yes, and then because I myself have this weakness earlier on, and I think I've seen other mooters have this like similar problem as well, is that they react too quickly, or some even cut off the judges. That's very terrible because like, you know, they are your judges, you're not supposed to disrespect them. So after they ask the question, some judges might take like a whole minute to ask their question, and that's fine. You will feel like, oh my gosh, my time is running out, you're wasting my time, but you cannot show it on your face. Let them finish the question, take 1 second and answer, because oftentimes that 1 second is what calms you down and what makes you have a sense of, okay, I can answer more structurally than going off the bat, because that oftentimes you'll just say things that are on top of your mind immediately instead of structuring it first. And then another thing, small thing to remember, is that maybe the first sentence of what the judge said already, you know, kind of know what question are they, what is their concern. But it's the best method or the best foot forward for you to do is to listen to the question completely. And it's a really minute thing that you wouldn't really realize until until you've gone through this several times, that sometimes you answer the question, you kind of answer it, but you don't really answer it as well. It's like a really weird thing, but because sometimes when the judges ask you a question, they are saying one aspect of their concern or their thought that they had earlier on, but what they really wanted to know is at the end of this their whole question. And a lot of mooters, what they do is that because they're so panicky, right? The moment the question is being asked, they're formulating their answers. And when they're formulating their answers, they start to like block out the rest of the question that the judge was saying. And that was my weakness earlier on as well. So yeah, I think it's really important for you to stay really calm during the exact moment that they're asking you that question. Have time to digest completely all of the questions, the whole of it, and then only you'll answer after taking 1 second. I think that's really what helped me for, you know, on the spot answering. And same goes to like the preparation things that Michelle and Stanley have elaborated. That goes into 90% of how well you will present said answers. Yeah.
Funny enough that being present is the most important factor.
Yeah.
For answering questions. Yeah.
So, do you have any more tips on how to deal with, nervousness and anxiety when you're presenting your oral arguments?
Okay, I will go first on this. Okay, I'm more clinical on this point, right? So I've read on certain articles regarding how to deal with nerves. Yeah. Because I don't really have stage fright, right? Thank God. But I think nerves is just inevitable. And biologically speaking, psychologically speaking as well, nerves are actually good to a certain extent, as it helps us become more focused, more alert due to cortisol and certain other hormones, of course. But let's not dive deep into those. Yeah. Regardless, what I'm trying to say is that certain level of nerves is good. So you shouldn't be trying to convince yourself that, nerves are bad. I need to ditch nerves altogether. Of course, when nerves cause you to blank out, then that's a big no-no, right? That's when you know, oh, that's too much nerves. But so I think the first step to combating nerves would be to accept that nerves is a good thing, right? Mentally. Then second way I do it is to, once again, psychologically, it is proven that when we are nervous, it may be because of one of two reasons. Either we are afraid or either we are excited. And our brain doesn't know how to differentiate between that two. So one of the ways that I have practiced myself for all these Moot competitions is to tell myself that I'm actually excited for the upcoming oral presentation, which it works. So you'll find me trembling in my seats minutes before my oral presentation. But once I'm on that stage, once I started maybe my introduction, Madam President, whatever, then you see me being absolutely natural. And I actually welcome questions. Questions allow me to just be myself and answer questions, right? So I think those are the two ways I combat nerves per se. I don't know. Sean, Michelle, what do you guys think?
Okay, so um, luckily for me, I don't have that much of a stage fright too. And the only reason that I don't have stage fright is because, do you know, back in the days in high school where you have the pretentious girl in class doing all the pretentious sharahan thingy? Yeah, that's me. So that person's me, and I've faced like 1,000 people in one day one, and then have to do the sharahan lah. So if I've done that, I can deal with 3 judges. But not saying that I will never be nervous. I will still be nervous, very nervous. And you can ask, I think, majority of the lawyers out there, they can have 5 years experience, but the moment they step into, or the moment before they stand up, they still get nervous, right? So know that you're not alone. Everyone is nervous. Your opponent is nervous as well. Okay, just because they look like, oh, they're very calm, then I can beat you. Inside, right? They're very nervous also. So put up a straight face. Scare them. Then yeah, knowing that you're not alone, everyone is nervous, and totally agree with Stanley. Like when you stand up, you're still nervous, but once you utter your first few words, it just go natural. You think like you're on top of the world. You just want to address the judge, and yeah, you just want to put your point across. You want to persuade them, and like Stanley said, give me questions. It just gives me the opportunity to demonstrate my knowledge of the law and show that I can handle whatever questions that's thrown to me. So yeah, and then I think having good teammates helps a lot in terms of nervousness and stage fright. They're legit your backbone, your support system. Knowing that they're there, I'm good to go, you know? And they will give you the reassurance that you need, despite your coach might not give you that. But don't not saying that our coach didn't. He did. He'll give you like a very last minute, very last minute. You okay, like you can do it. But sometimes it's okay to give reassurance, but to each other, that you have the hang, you get the hang of it, you can do it. So yeah, those are not really like anything positive acts that you can do to combat those stage fright, but it's just a matter of, again, practice. As cliche as it sounds, you practice so many times in front of different people, in front of your friends, then you just feel like those judges are just any other people that has heard me before. Or yeah, that's from me. Shuhan?
Oh, I tell you, it's so true that you never get rid of the nerves, no matter how long you're in this game. Every single time before you present, you'll feel nervous. But if you don't feel nervous, I'm sorry to say this, but it means that you don't care enough. Because you really care about how you're going to present. You're going to be thinking left and right, like, oh my gosh, what kind of questions will come up? And then those are the things that will make you start to like panic. And that's perfectly fine, I think. So like what Stan said, being nervous is good. It's a good sign. And from my perspective, it's because you care. And from like echoing what Michelle said just now, I think it's really important for us to emphasize that the nerves goes away when you stand up to the podium only because you were prepared. So if you did your research last night for the whole moot problem, you know that you're not going to handle questions, so I'm sorry, I cannot help you. But if you have spent the entire 2 to 3 months working on a moot problem, going into details of every single thing that might come up, you're going to be fine. And you will know that when you step up to the podium in front of the judges. So the only way to get rid of the nerves is really to prepare well. And yeah, I think, and lastly, tying back to my earlier point, one way for you, no, actually it's a little bit of a different perspective. One way for you to really not feel as much panicky as you would normally is that remove the setting from a connection to your personal traits. Like, how do I put it? Don't put it as how I present today will affect how I am like or how people perceive me as, because this is bigger than just yourself. you have to put yourself in the mindset that you're trying to build a case for your client. And once you're in that headspace, everything is much better because it's removed from your personality, and it's removed from personal judgment. It's simply about the case, what the case says, and what you can say about the case. Everything is not tied to you. So once you have that, you just kind of become a little bit more robotic, And once you're in that headspace, then the nerves will slowly fade away. Yeah, so preparedness and knowing that you're assisting the court are the two things that help me. Yeah.
Oh, I have something to add up. This is very minute. All of you might think it's a bit ridiculous, but it works for me every time. It's to, okay, it differs for everyone because I think nerves, right, ties back to your confidence. I mean, again, if you prepare enough, you'll be confident enough. But there are other little things that can contribute to increasing your confidence. For instance, for me, wearing my high heels, right? So even if it's an e-moot competition, I can be formal up here, but then I can be wearing my pajamas down there. That's up to you. But for me, I like to go full suit, high heels, even indoors, because that's what makes me confident and feel the part. Like, but that's for me. If any one of you have, for maybe guys, maybe a specific tie that you think that, oh, I love it so much, I must wear it, wear it. Lipstick. I can don't go too crazy. Like just because you like a black lipstick, then you wear it. No, you still have to be like formal, appropriate, or maybe like a certain notebook, a certain pen that you use, right? All these just goes. It matters for me lah, because I remember, I was wearing my high heels indoors at home, and then my teammates were like criticizing me, like, oh, what are you trying to do? It's not like they can see your shoes. But I'm like, I don't really care. I just want to wear it. Then I think that contributed to my confidence. Little things, subjective, different for everyone. Yeah.
Yeah, I think. Yeah, I mean, because we're on the topic of nerves, which pertains to your mental side of things, right? So everyone is different. Some people handle pressure different from others, right? For example, myself, I think I work okay under pressure. Like with a certain amount of pressure, I can focus better, um, and all that. But some people just really dislike or despise even pressure, and that would make them work less effectively as they would without the pressure. So that really comes down to, like how Michelle say, you have to look the part as well, right? If you are feeling like you are the best, then you will perform at your best, right? Because it's, like I said, it's mental. So whatever actions that may help fortify that mental fortitude would help in your performance, right? Whether it's doing any rituals, or like Michelle, she has to wear high heels, which I don't think it's a problem at all, right? Because it's your personal preference. But yeah, whatever that you think may help fortify that mental attitude of yours, do it, right? Yeah.
Thank you. Thank you so much. So, what are some common mistakes that mooters should be avoiding during their oral arguments?
I can start first, maybe. Yeah. So, okay, I'm gonna say this based on my own personal experience, and I think this applies across the board, whether you are beginner or you are a veteran mooter, because I make these mistakes myself, and my coach would be, correcting all these mistakes for the entire period of my preparation. So I think one of the common ones for me myself, I think I tend to say apologies a little bit too much, right? During my submissions. So every time I feel like maybe it's because of a presupposition that everything has to be perfect. So for example, let's say I mispronounce a word. I would have said, oh, my apologies, Your Excellencies, which is, yeah, totally unnecessary. Unless you really give out a wrong point. For example, let's say you are the applicant and you suddenly say, the respondent submits, oh, then that's a major problem. So that warrants my apology. But for me, yeah, that is one of the problems that I had. Second is breaking character. I don't really have that problem, but sometimes I may be a little bit informal. So that I have to keep conscious as well. I have to make sure the way you smile, the way you present yourself, carry yourself at the podium matters. So certain times where you smile informally, as if you're smiling to a friend, for example, would play differently, especially depending on the case that you're presenting. Let's say the recent case that we are presenting is concerns civilian deaths in military conflicts. So clearly, it would not be an appropriate situation for you to smile weirdly, right, or have that weird grin on your face. So I think that and maybe filler words, like for example what I just did, those are, I think that goes without saying, that you shouldn't add filler words in your oral arguments. So I'll keep at those three personal mistakes that I always have. Michelle or Shohan?
Okay. This is a common mistake that is made by a lot of mooters. Fortunately, not us, because we'll be in big trouble. Addressing the judge, right? You're panicking. I understand, but sometimes, Your Excellencies, you might say Your Honor. Okay, maybe for PIL cases, it's a bit better. If it's like a court case, if the judge is a guy, you probably say my lady. Oh no. Some judges are okay with that, they understand that you're nervous, but some don't. They make a huge fuss out of it. They think like, oh, is it not obvious that I'm a man? Okay, no, they won't say that, but it will be reflected in your comments or your mark. So get the address right, because that just shows, I wouldn't say credibility, but it shows, preparation again. Have be very calm and composed that you get the judge's address right. And again with Stanley, echoing him, filler words. My problem back in the days is that I use the word therefore a little bit too much. Like every sentence or every paragraph there's a therefore or hence or thus. My coach would tell me things like, okay, so what is the conclusion? Then I'm like, oh yeah, I said a little bit too much. Or even record yourself in that matter. Record yourself, look at yourself. Previously, our coach actually made us watch our recordings, and it's painful. It's really painful to watch yourself. I think you guys would understand. You record your own voice message and then you listen and you're like, oh my God, I sound like that. Yeah, we have gone through that so many times, not to mention we have to listen to our voice like 20 minutes. Yeah, but from there, you get to know, oh, this tone is a bit weird. Or practice in front of the mirror. Oh, that weird grin, inappropriate. So then you'll know. Okay, and the last mistake, it's not a mistake. Probably you guys would think it's beneficial. It's style, a matter of style. So you can go on Facebook Live or YouTube and find a mooter that you think, wow, he or she speaks really well. I want to be like her. Then you try to be that person, which might not work for you. That is not your style. Because previously, I'm not so sure. I may have toned down a little bit, but previously I was a very aggressive mooter. I'm much more out there. And I've been told to calm myself down. And it impacted me a lot because that's just me. That's just who I am. I can't really change how I speak to just become monotonous, right? You cannot satisfy everyone. Every judges has their own preference. Some judges prefer mooters being aggressive, not like aggressive to a very bad extent, to a certain point where they think like, oh, they're really passionate. They feel for the client. They're empathetic. You know, you're not just doing the mood problem just because my client paid me, right? Some judges prefer that, but some judges prefer mooters that are more calm. Stanley is definitely calm. I think Shuhan is calm, right? I think I'm different. Stanley is definitely calm. So that's why when he said like both of us make a good dynamic, is because he's calm and I'm aggressive. So it's like different styles. So you have to find a style which is suitable for you. Just because someone tells you, oh, don't be aggressive, or don't be too monotonous, you have to give a little bit more intonation. Okay, take that with a pinch of salt, take it constructively, and work towards a style which suits you the best, which you feel most comfortable with. Yeah, because you will hear a lot of differing opinions. One judge says, don't give me hand gestures. One judge will say, you have to signpost with hand gestures. Then, so who do I follow? So again, boils down to what suits you best. Yeah, that's from me. Shuhan?
Yeah, I think everything that Michelle and Stanley said, I personally can relate to as well, especially the one about certain comfort words that you will fall back to, right? Like for Michelle, it's therefore. For Stanley, might be filler words or apologies. For me, somehow it was simply. And so I think it actually applies for everyone, that you will find yourself going back to that one or two words that you will keep repeating when you're trying to think what to say next. And it's not simple as identifying it and the next time you wouldn't do it. It actually took me like 3-4 sessions before I can actually control it. So it means that a lot of these mistakes, know that you cannot just identify it in one setting and the next time you'll get rid of it. It takes practice to get rid of it. And all of these will keep coming up when you're nervous. So you really have to go through it multiple times before you can actually get rid of your common mistakes. You have to really remember that. And then another thing that I think most or some of the mooters will have a problem with is the speed of your presentation. So I personally struggle with that a lot. When I'm nervous, I speed up because one is the time pressure. Two is that my mind is turning really quickly and I'm trying to get to my next point as fast as possible. So that simply will not help. See, I say simply again. That will not help your case because the judges cannot follow you. And if the judges cannot follow you, they don't know what you're talking about. And if they don't know what you're talking about, your marks will go down, your whole argument will fall, things like that. So a reason why I personally speed up as well is because I'm afraid of questions. This is like a very earlier on mistake. I want to get through this argument as safely as possible. And I subconsciously feel like if I go slow, maybe the judges will get bored. Maybe they will start to have questions to form in their mind, which I can actually answer in my later submission. These are things that you don't have to worry about. If they ask you questions about what you are going to present later, that's great. You will seem like you're so prepared, man. Like you're presenting on this surface level introduction of your argument, and then they start to ask you about something more detailed, which you were actually going to present. But right now, when you answer it, it seems like, oh, wait, she knows everything that I'm going to ask. So get rid of unnecessary concerns about the time pressure that you're in. You are under time pressure, but you should never ever speed up your submissions. Even in the last minute of your submission, you shouldn't speed up. Just like tying back to what we've said earlier on, know how to structure your arguments, know how to prioritize them. And that should get rid of the common mistake of being like too fast for the judges to catch up and things like that. Yeah, I think that's all from me.
Oh, I have 1 point. Oh, Stanley. Okay,
No,
I'll
no,
go first.
go on. Yeah.
Okay. And a common mistake, engagement with judges. A lot of times you're nervous. You just want to present everything that's in your hand as fast as possible. Not in terms of speed, but you just don't care whatever appears on their face. it's very important. Engagement is so important to a point where sometimes when they scrunch their eyebrows, then we'll know, oh, they have a questions coming up, right? So just pay attention to their little facial expression, or if it's an emote, when they start unmute the mic, then you know they have a question. Then it's your cue to stop and pause, to ask them whether they have a question. It's only if you're very confident that you can answer whatever they're about to ask. If you have no confidence, then don't attract questions. But the point I'm trying to get is you have to observe your judges. You have to be as if you're in a conversation with them, and you have to talk with them, have a talk with them instead of talking to them. And another very obvious example of lack of engagement is if you want to refer the judges to a certain document or the moot problem, if I may refer the courts to page 36 of the facts or paragraph 36 of the facts, then you straight away submit whatever you're about to do. Submit, then the judges were not even there, they're still flipping, right? Then that's not good. You should see and observe, okay, they are there, they are following you, they stop, they look at you, then you proceed with your submissions. Because it's not going to look good on you when you ask them to refer to a certain page, but you don't wait for them. And all that boils down to being engaging with the judges. And I think a lot of mooters lack in that. They don't really observe the judges. Yeah, so they just read whatever is on the script, if you have one. Yeah, that's a common mistake. Sandy, you have anything to add?
No, that was actually what I wanted to say as well. So yeah, you covered it pretty. Yeah, you pretty much covered the whole thing. So I think that's all for this.
So, can I ask, how do you address counter arguments from the opposing team?
Okay. I think this is my turn because I love being a respondent. So this question would apply to respondents and also for rebuttals when you're either claimant, prosecutor, applicant, answer rebuttals. So to address counter arguments, again, remember that you have to respect your opponent. You're not supposed to attack them on a personal level. So personal level attacks are things like my learned friend has mistaken the facts of the case that they have cited. Oh, that will be terrible. I mean, some judges might secretly like it, but most of them will think that you're disrespecting your opponent. So when you address counter arguments, address it removed from your personal level. Approach it in a very learned manner, you know? You're just trying to assist, once again, assist the court to understand why is it that you don't agree with what your opponent said instead of saying that your opponent was wrong. Because you have to know that your opponent also spent like months preparing for the competition. They're not going to just spit anything that they thought of this morning before the competition. Those are the things that they prepared, and there's a reason why they're presenting those arguments. So approach it clinically. Just address whatever that they said in the best respectful way that you can. And most importantly, as a respondent, is that this goes back common mistakes actually, that respondents, especially in the very beginner level, they are only presenting their case as if they are talking like the claimant or they're talking like the applicant. As a respondent, you should be addressing everything that your opponent has earlier said. So this goes to, there's personal preference as to whether or not you should structure your arguments according to how your opponent addressed it. So maybe earlier on in your preparation, your arguments were structured A, B, C, D, but when your opponent was presenting their arguments, it goes like C, A, D, B. So should you follow that? Should you not follow that? That's up to you. And also according to how you think would best, lead the court to understand your case step by step. instead of throwing them off guard. But to address counter arguments is to match at their level or even on a higher level of what they say. So for example, if your opponent said something about I'm depending on this case because this case said this, it applies here and it will be in our favor, then a way for you to counter that kind of argument is with the weakest kind of way to counter that is to distinguish the case facts. To say that, oh, because in that case, right, actually the claimant didn't do this, where in this case we did. So that's why it is different. You shouldn't depend on that case. The better thing to do is to go into the principle of the law, like what Stanley said earlier on, the rationale behind why the law is like that. So go from that standpoint, and immediately the judges will be on your side. They would love it. You would sound really learned, and you didn't attack your opponents in that whole process, which is really great. And then for rebuttals and rebuttals, you just have to survive, lah, honestly. And it goes back to preparation because I think rebuttals for claimant or the first side that is speaking is at least better because you have the whole 20 or 40 minutes to prepare whatever that you're going to say. But still, it is quite on the spot. So it really depends on how well prepared you are in terms of all of your arguments. And for rebuttals, I think for both rebuttals and rebuttals, it is the most common place where you will speed up in your arguments or in your presentation. So that is also one thing for you to like really remind yourself of, because as much as you really can't control your speed and your demeanor during your core submission, things will get messed up when you stand up for rebuttals because you're so nervous. You're under like 2 to 4 minutes to end your speech. You're going to go through it like bullet train. But know that in rebuttals and rebuttals, it's not about quantity, it's about quality. Of course, you have to present like more than 2 points, or else you look really lame, you know. But know that it is better for you to present your whole argument in a very understandable manner, and that is more important than addressing 4 points and the judges actually don't know what you're talking about because you're going too fast or you're just picking very minute things that don't really matter. Yeah. I think that's what I can think of now. Michelle, Stan.
Okay. Just before I say my point of view, I just want to share an experience where I was attacked. Stanley is there to witness lah. Not sure. I was attacked by my opponents, saying that I believe my little friend it wasn't paying attention. Oh my god, that's so bad. I felt attacked lah. But again, just because they attack you doesn't mean you have to fight back. You have to retaliate. No, be the bigger person. Be the bigger person. Judges can see with their own eyes. That's one. And then how to handle counter arguments is to be attentive. Again, cliche as it sounds, you will be so nervous you're just looking at your script or whatever that's in front of you and you're not paying attention to whatever your opponent was saying. You have to be attentive. You have to listen to what they're about to say, not just to your opponents, but what the judges are asking. Because most of the times when you handle counter arguments, right, it's from the judge's question. Because why do judges question them? Okay, number one, seek clarification, yes, but they also think that there are certain loopholes in their arguments in which you can use it. You should utilize those questions to your benefit in terms of forming your counter arguments. And if you slip in a phrase like, as correctly pointed out by young Arif, judges will feel really happy, like, oh, you're actually listening to me, and then my point is actually valid and you're using it. So it's only good for you to be attentive, to use judges' question as a basis or as a supporting factor for your counter arguments. Yeah. And then what else? Preparation. You just have to prepare with your teammates so much. In the past, we have a list of rebuttals and rebuttals, but I don't think that is super effective because anything can happen in the rounds. Any new questions probably can also be formed by the judges. So you again have to be flexible for rebuttals and rebuttals. Yeah, that's for me. Attentive, be flexible, and respectful. Yes.
Stanley?
Yeah, just to qualify Michelle's experience a little bit, I think when you are attacked personally, for example, like what Michelle experienced, and when the opponents say that you are wrong, you are annoying, whatever. We have, some opponents. I think in the recent competition, there was a case. I think during my rounds, my teammate and I think the opponents referred us to being ignorant. Yeah. So, but we didn't have that experience. But later on, our coach told us, if you face such a situation, correct, don't fight back by saying that, oh, we are not ignorant, you are the one being ignorant. So that's the wrong approach that you should take. But you should point it out to the court by saying that, I believe that we have been very careful when making our arguments, and certainly we do not ignore any problems that this court may have. So point out that whatever your opponents are saying are essentially wrong or accusational, right? That's the first thing. Second, I think, once again, I echo both of my co-panelists' view on this, that you should be very prepared, especially for respondents. You should be very well versed with your script so that, in the rounds itself, you can just focus on what the opponents are saying, which is what I have experienced this round. So I haven't been as prepared as I had for this competition. And that's all thanks to my teammates and my coach, honestly. So being that prepared gives me an advantage. When I'm the respondent, I'm fully invested into what the applicant is saying. So for example, I remember clearly they have 4 points, right? And I have responses. I will write in point form exactly what responses I have. And I attacked every single response. In fact, a funny experience, I think Shuan is there to witness this. I attacked 3 of the, so I'm doing issue 3 and issue 4. I attacked 3 of my opponent's arguments. Then I said, oh, okay, I'm now going to move on to my 4th issue. But suddenly I remember, I looked at my paper and I remember, oh, I have a 4th response to make. So I had to say, my apologies. If this court may just allow me to make a final response to this argument. So that shows, because I'm so well versed with my script, I'm not confined by my script, right? I can use whatever knowledge that I have in my script or not to make my responses. And I think that goes for rebuttals as well, right? You have to be so attentive as to what are the potential problems or downsides of your opponent's arguments so that you can formulate your rebuttals. And like Michelle said and Shuan said, that goes to being attentive as to, noticing the confusion that judges have, whether the judges like this argument or not. Let's say they are not particularly, they're not particularly persuaded by this counter argument. They can attack it more by saying that, exactly, this is why this court shouldn't consider this argument, right? Because you have that advantage that they are not on that side, on their side already. So you can use that to your strengths. And then if judges have a lot of problems with a particular argument, or they like a particular argument as well, then you can attack it as well in your rebuttals, also rebuttals. I mean, rebuttals, you don't really have a choice, simply because you are confined to whatever the applicant is saying. But rebuttals, if you note that, judges are persuaded on one of the points, then you can attack the point, because you know that is the strong point that the opponents are hopping on. So if you can break that strong point, then clearly your case will be way stronger from the outset. And I think the basic applies here, like what Shuhan said, attack the rationale, not the legal authorities. Because, I mean, honestly, we can always just bring up a bigger legal authority. You will say A, case A. I will say, oh no, UK Supreme Court says this. Especially in international courts, it's international. You have so many different authorities to rely on. So I think, attacking rationale is the best foot forward, as propounded by my coach. Yeah. Umashri?
Okay, thank you. So let's move on to the tips for beginners. We have another 10 minutes to talk about this. Do you have any more tips that you would like to give to beginners?
Go on, Michelle.
Okay, first thing, read your mood problem. When I say read, it's not just looking at it, flipping, oh, I know the story. That's not the case. When I say read the mood problem, I think nearing the competition, I was still reading the mood problem because I just want to know A to Z. And at that point in time, I already know my facts at the back of my hand. I know paragraph 49 says about what. I know this specific fact is at page 55. You have to go, like, you will reach that point if you practice enough. That's the extent of reading it. And most importantly, you have to understand the facts are there for a reason, right? The drafter drafted it this way for a reason, for you to argue, for you to support your arguments, and be very attentive to details. It goes to words such as and, or, shall, like very small words can make or break your case. So the first thing as a beginner is to be attentive to details in the mood problem, and how to do that is to actually read the mood problem. Okay, that's the first thing that I can think of. And the second point is to have fun. Whatever we said just now doesn't sound any fun, but it is fun because it is evidently shown when you see us repeating this all over again by doing another competition, because we had fun. The preparation is torturing, but you have good friends there, and at the same time, the sense of achievement, accomplishment after every round just motivates you and drives you and thrives you forward to do another mood. So this is what my coach always say, is to have fun in every round. And when you have fun, everything will fall in place, everything will just go right. If you go into a competition thinking that you're not going to do well, you're not going to be able to answer the course question, it's just not going to be right. You're just going to go in and have fun. At the end of the day, whether you perform well or not, it benefits you regardless. If you perform well, then you know this is the right thing to do. If you perform badly, then you know what to change. So don't be intimidated by whatever that we have said. It's only for the good. It is only for the good. Maybe the only bad thing is you sacrifice your social life, but it's okay. Social life can wait. Yeah. So there are two things to bear in mind. Number one is to read the mood problem, and number two is to have fun. If I have anything else to add, I'll add after this. So, Shuhan, Stanley?
Okay, yeah. I think there's one thing that until the most recent competition, I was still trying to improve on, is to be able to organize your research. So what I meant by that is that throughout your whole few months of research, you're going to come across very different sources, cases, scholar articles, conventions, articles, things like that. And there are times where you will come across, for example, this article said specific things about the law, but at that moment you feel like, oh, this is not useful, then you just move on to read the next paragraph or the next article and stuff like that. But 1 month down the line, you will regret that you didn't write down that article because now you know that that was helpful. So things like that means that even in the most minute sources that at first may not seem that helpful, it might turn out to be something bigger later on. At least in my personal experience, it was like that. So I still couldn't really manage to keep track of all of my research in the most recent competition, simply because we've spent so much time researching and there's so many things that went on. But just make sure that you keep track of what you have found. If you feel like it's relevant but not helpful, note it down because you never know. So you don't really have to do it in like an Excel sheet or like a spreadsheet. Just take out a Word document, a Microsoft Word document, and then I name mine as brain dump, issue 1 brain dump, issue 2 brain dump, and then I'll just put like small headings of what is this main point, and then down there I'll attach the link to that argument, and then maybe sometimes a bullet point about what the argument was talking about. So later on, it really served me well, these brain dump documents in the later stages of the preparation, because sometimes we'll think of, oh, maybe you want to try this argument. Then I'll remember, hey, I actually came across this article that talked about something similar. So I just can go back to my brain dump document and just find a keyword, and it will be right there. The link is there. So it's really, really helpful. So yeah, I tried to incorporate that. I think that's what I wish I knew in the very beginning of my Moot journey. Yeah, because sometimes you feel like you're wasting a lot of time reading one thing, but it's actually helpful for you to read through everything that you can get your hands on and keep a record of that, and it will help later on. Like what Michelle said, I'll add on if I can remember anything later. Cannot remember anything now. Stan?
Yeah, I don't have any particular tips to give because I think we have really expanded on everything that we can remember, right, throughout the whole 2-3 hours that we are, spending here. And I think maybe for some of you, it's a lot to process. It's very overwhelming. And I get that because I think we are who we are now, not because we are able to incorporate all these comments in one competition. It took us 5 for me, 6 for Michelle Shuhuan to get to the level that we are right now. And we're not trying to say that we are very good mooters. I think we are above average, but there's certainly a whole lot more room to improve, right? If you look at mooters from Singapore and all that, you can see them on YouTube. You will see those kind of levels are the levels that we would like to strive for, right? But all I'm saying is that, yeah, it may be overwhelming, but just let's say if you're participating in your first Moot competition, then it really depends on how much you can incorporate in that first competition. Don't try to, of course, try to incorporate all, but don't beat yourself up just because you didn't do every single thing that your judges may tell you, your coach may tell you, or we told you. Yeah, don't beat yourself for failing to do that because it takes time, and we're talking about years. In fact, I think when I'm a lawyer next time in the future, the same thing, I will carry all this with me, and each case that I'm dealing with, I will improve myself from there on. So I really don't think there are any more other tips to add on at this point that I can think of, unless Michelle Shuhan has anything to really add on. Yeah, I think it's just hard work. It's very cliche, but I really don't know how else to describe our preparation. Hard work.
Well, I think one last thing that I can say is that throughout this last few hours, 1 hour and a half, whatever that we said to you, know that you can personalize things. So we might have said some stuff that might not exactly work that way for you, and that's perfectly fine. And you wouldn't know until you try it. So just, the first step is to try it lah. But this applies also to feedback that you will receive from your seniors. This also applies to comments that you will receive from judges. Because all of these things, all of these comments, to a certain extent, it will come from a personal capacity. It will be influenced by their personal experience. It will be influenced by their preference. And so it doesn't mean that 100% of it would apply to you. And in the beginning, it's really hard for you to discern what to take in, what to not. But just like what Stanley said, you will learn throughout the progress of your Moot journey. And so it means that all of these tips, feedback, comments, if it's adverse to what you're doing, don't take it personally. Don't take it like something that, oh, I've done so wrong about, because it might be just not that wrong. It's just that it's a preference, or if it is wrong, it is okay. You're a beginner, and that with practice, all of us will, progress somewhere else, and we are all trying to improve. So yeah, just how to say, adopt a learning mindset when you go into moods and anything in life, but like especially in moods, just know that every single stage is a learning process. You will never get to a stage, even as a lawyer, you will never get to a stage where you have perfected everything that you should. Yeah.
Yeah.
So
Yeah, I agree.
that's all.
All right.
Sorry. Are we proceeding to the next session already?
Yeah,
Okay. Sorry. Okay. Okay. Just a quick one. In this whole journey, if you decide to venture into more competitions after your internal mood, you'll find yourself questioning your ability. That's what I've experienced. You see me speaking confidently now in a workshop, but the tears, the sweats, the blood that we've put in, it's crazy. Maybe not for Stanley though, he's emotionless, but I have my moments where I actually think that, oh, probably this career is not even for me. That was during my KL bar session, because the guest judge was questioning me, throwing me questions left, right, center, and I couldn't answer. And you will find yourself in that situation, and that's perfectly fine, because look at me now. Back then, it's okay to cry, it's okay to rant, it's okay to complain to your teammates, because they will understand your situation. Yeah, so don't give up just because you question yourself at that specific instance, because in the long run, yeah, you see yourself improve. And then you look back, and when I look at myself, 2019, when I first started, I think I got the judge's name wrong. No, not judge's name. Like, I cite an authority. It's Lord Justice. For example, Lord Justice Denning. For example, I say Denning Lord Justice. It was stupid, but that just goes to show how far we've come. Yeah, and that will apply to all of you if you decide to do more moods in the future. Yep, that's all from me. You must read.
All right, so we can proceed to the Q&A session. So all participants, you can actually send in your questions through the chat box, or you can turn on your, you can unmute your microphone and ask them questions directly. I'm also looking at our FB Live, and we have some questions coming in from there as well, and some questions coming in through WhatsApp. So maybe I can start by reading some of these questions to you.
So it is public.
Yeah.
Okay. All right. Sorry for
All right.
cutting you off.
Well, let me find these questions for you. I guess there are some questions in our chat box here. From Faris Akmal, some how can you effectively incorporate customary international law into your argument and establish a connection with existing conventions? Would any of you like to answer that question?
Okay, I think I'll go first on this. I don't really understand particularly as to what you mean by connecting the customary law to existing conventions. But based on my understanding, as to how you can incorporate a particular CIL, we call it, into your legal arguments, I think that really depends on what CIL you're arguing. So some CILs are very settled. For example, let's say the non-intervention principle, principle of due diligence. Those are very settled. What do you call that? Settled CILs. But it's the matter of application that concerns most judges, because a settled CIL may have different ways or different methods of application. For example, non-intervention rule, we date back to 1960s, 1970s. We have that seminal case of Nicaragua. those are all pertaining to non-intervention in military forces. So it says that a country cannot invade or intervene in another country's affairs using military forces. But now we are trying to use the same principle by saying that countries cannot invade another country using cyber technology. So you see, the CIL is settled, right? The concept of non-intervention is very settled. You know that it is a CIL. But now you are trying to extend its application to cybersecurity issues. So I think that's the connection that you're trying to make. As to how you link CIL to existing conventions, to the best of my knowledge, what I understand is certain conventions or treaties may be evidence of CIL, if that's what you're asking. So for example, UN Charter, Article 2.4 is your typical, archetypical example of the CIL of non-use of force. Some may argue that it's a use cogence, but let's not dive into that. But it's sure that it's a CIL, codified in the UN Charter. So I think that's the link that you're trying to find, or unless my co-panelist differs in their view.
I think a possible reason why you might ask this is that there's a certain convention that says a specific thing, but your party is not a signatory to it. So you're trying to say that it's a CIL. If that is the situation, then cases would help. If you can find a judgment that says, for example, what Stanley said, non-intervention principle, definitely there will be a case out there that a certain judge, or in the judgment itself, it says that, oh, this is a custom, it has reached a customary status. Then you can just use that sentence to help your case. But yeah, so just make sure that you understand how are CILs formed.
Good.
So know that there are two sides of it. You have the opinio juris to it, and also the state practice to it. So make sure that you are able to substantiate your argument to say that it is a CIL because this judgment says so, and because states have already implemented this, and it is shown through whatever legal authorities that you can find that they are accepting this as a legal obligation that they have to follow as a country, as a state, then you can establish it. I think that is where the person asking is coming from. Otherwise, yeah, I think whatever that Stanley said would apply. Yeah.
Though I have to caveat that if you're trying to argue a CIL from scratch, opinion juris, state practice is still okay. I mean, you can find state practice pretty easily, but opinion juris is a huge hurdle to overcome, right? So just take that into consideration.
All right, so there's another question from Faris. Could you provide a brief explanation of the procedure and processes involved in the competition? Specifically, what is written memorial submission, oral submission, and any other relevant processes? I think you've gone through a little bit of this. Is there anything else you would like to add to it to answer this question?
Okay. So if it's the first time you're doing Moot, all of this will be like kind of overlapping. But in terms of procedures and process, I believe it depends on each competition. You can just look at the rules and regulations for that specific competition and what procedures that needs to be done, when do you need to submit, and all those. But there's probably like a confusion, like what's the difference between written memorials and oral submissions? Isn't it just like me reading out the written submissions? It's definitely different. Written submissions, okay, generally speaking, are more detailed. You put authorities, justifications, and everything that possibly you can formulate into the written submissions. But oral submissions, like whatever that we've just been talking about for the past 2 hours, it's that you have to pick your battles wisely. Whatever is in your written submissions, right, you won't be able to say everything because it's too much. So oral submissions is where you pick your battles from your written submissions. Yeah. That's the main difference. And then for written submissions, it would usually be a month before, but your competition is 2 months. So I'm not so sure how early on and whether you can depart from your written submissions, because some competitions, they wouldn't allow your oral submissions to depart. But what I mean by departing is where you say a totally different thing. For instance, you say there is acceptance of a termination of contract, but then you think, oh, we didn't accept it. So that would be a total depart. But just because your written memorials doesn't have a case, it doesn't prevent you from using a case that you found subsequently or afterwards, right? So again, boils down to your rules and regulations. Do pay attention to whatever ILSA is providing you. Yeah. Anything from Shohan, Stanley?
No, I think you you covered it pretty comprehensively. Essentially, in one sentence, written submissions is whatever that supports your case legally. Oral submissions, you are trying to persuade the judge. That's all. And you don't persuade people by using verbiage, right? You don't tell them, because I have case A, case B, case C, case D, that's why you should follow me, right? That's not the case. You should tell them why. And it doesn't necessarily have to be legal authorities, but of course, legal rationales and all that would help in persuading.
Okay, so we have another question. How are the written submissions, the memorials, evaluated?
This one, ask your organizing committee. No lah. How is it evaluated? I think normally the first one is, of course, how strong are your legal arguments? And actually, the aesthetic part of it also plays some role to it. So my advice is that I'm sure later on you have another workshop, right, on written memorials in specific. But if you want the answer now, you can search up for Jessup winning memorials. They publish it every year since, I can't remember, 2012 or something earlier on. You can look through it. All of them are available. So then you will have a good grasp of what a memorial would look like and how it should look like. And other things like how your citation formats should be and all that. Just follow what your organizer set it as in their rules, then you'll be fine. Yeah, I don't think I can elaborate much. Stan, Michelle?
A common mistake made is that when you draft a written memorial, you have the urge to use flowery languages. And that is definitely not needed. It would just confuse the readers. So what you want to do is use simple language. Don't make one sentence as if it's like one paragraph. Keep it short, punchy. Even more so if it's oral submissions, but written submissions, you can be a bit longer, but don't be like one paragraph is one sentence. Keep it short and simple, easily understandable. Yeah, for written submissions. So it's based on clarity. I think when you look into a written memorial, clarity, how straightforward your point goes, don't beat around the bush. Formatting. Formatting. The paragraph justified or not, same font or not, spacing, all of this just is very important, despite it sounds like really minute, but it is important. Formatting your language. Yeah, that's for me. Stanley?
Okay, so another question. How to effectively manage your stress during the moot season?
Okay. Let's calm down. I think how to effectively manage stress. I think we don't effectively manage stress in some ways because, like Michelle said, I think we give up a huge part of our studies for Moot so that our brain capacity can handle the level of stress that Moot is giving us. So I think effectively is an overstatement. In our case, of course. I mean, I'm sure there are. Okay, I don't know if there are anyone that can effectively manage stress, but I think for myself, maybe one way to manage stress is to really just, it comes down to how disciplined you are. So maybe you just set a block of time for mood preparation. Because I understand that you guys have to attend classes. Like what Michelle said, attendance is probably compulsory. So maybe a good way to do is to block out time. And for that time period, really just focus on moods. And I'm talking about real focus, like with no phones, distraction. I'm not like some focus guru or anything, but I think that would help you achieve the most you can within that specified period of time. Hence, then you can leave some other time for your social life, whatever revisions that you need to do. So I think that's the only sort of way I can think of, though I don't really practice it myself. Johan, Michelle.
Neither do I.
Yeah.
Effectively manage stress. I don't think you can even manage your stress even even like after you start working. That's just one of the very proud characteristic of a legal career lah. How to manage stress? It's okay to cry. I cry a lot. I'm not gonna sugarcoat it. I cry a lot. I think that's my form of releasing stress. I cry. Then after crying, then I just know that I have to do my work. Then I'll be crying and I'm still doing the work. So I don't think that is effectively managing stress, but it gets the work done. So
correct.
yeah. So it's okay. If you want to cry, you want to cry. If you want to punch a pillow, go ahead. Anything that works for you personally.
I think bottom line is whatever that gets the work done lah.
Yeah.
Bottom line. Doesn't matter how you get there. Sure.
Yeah.
Yeah, you really can't really effectively manage your stress because it's really unpredictable, your stress levels. But I think for me personally, what helped the most is my teammates. Because if they're not there, I think, I don't know. Okay, so from that, I mean that you should really, really form a good team dynamic with the rest of your teammates so that you guys can support each other throughout. It's not just emotionally. Sometimes you're researching some things, you hit a roadblock, you can search for your teammates' help and stuff like that. And so it goes back to our earlier suggestion that it's best if you have more physical trainings, you meet up more physically. Because when you asked about stress, that one moment that I remembered was when we were preparing for memorials and we have our internal deadline a few hours away. We were in our BAC library. We were blasting rap music. And that was how we got through that really stressful moment. And so it really rings through for me that once you have your teammates with you, and you guys handle the situation with, I don't know, humor as coping mechanism, things will be okay. Yeah. Other than that, just make sure you eat well, sleep well, although we don't really do that, but I think that really helps. Yeah, that's all.
All right. So, do you have any of motivation to participants present today to encourage them to join mooting competitions in the future?
Join, why not? Join, I think all of us dived into it in a very different way. For me, it was just because the Moot Club said, oh, it will be a good exposure for you to attend this audition for IHL. So I went. And then mana tahu I got in. And then, so just do it. It doesn't really require you to have really good skill sets at the get-go. Like what we said earlier on, you don't have to be a great speaker to be a mooter. So, yeah, just the first step is always the hardest, but okay, no, actually that's not true. The first step will seemingly be the hardest for you right now. Just take it and things will set sail from there. And you can see that the three of us really enjoy, all the thinking back to all of our mood experience, and it really helped us. Oh, one thing that I wanted to mention in the first question itself, and I forgot until now, is that one thing about joining mood competitions is that it really helps with your connections. And if you are going to be in the legal field, that really helps you. especially if you're able to strive well in external competitions, you're going to get connections from law firms, from lawyers. You're going to be active on LinkedIn, connect with them and all that. And so that is one like maybe a little bit more surface level thing that I can speak on, but it really does help for your future career advancement and whatnot. But yeah, aside from that, it's like skill sets you'll get to develop, you get to meet friends that you will eventually be really close friends with. And then it also really helps in your, like normal studies, because now you can think faster and in a more analytical way when you approach legal issues. There's just so much benefit. And like I said, right now, the first step might seem daunting, but the journey will be very, very worthwhile. Yes.
Yeah, I mean, yeah, what's the downside lah? Ask yourself. What's the worst thing that can happen if you join a Moot competition? I mean, the worst case scenario, you lose. But yeah, that's pretty much it, right? You don't lose a limb, you don't die or anything. There's really no downside to it. It doesn't require your money. Well, time is one thing, but other than that, really there's no downside. And then the potential upsides are whatever that Shuhan has said. So if you weigh that out, do a normal cost benefit analysis, I think it's more, it's very obvious that it's a no-brainer for you to join Moots if you are really interested in to do it. Michelle?
Oh, for me, another one, even more surface level, shallow. You can put it in your CV, so why not? If not,
another
your CV
potential
will be
upside.
empty. Yeah, so just do it for the sake of CV. You want to stand out. Competition is great nowadays in securing a pupillage, a position in a law firm that you really want to go in. So yeah, participate. Moot.
Yeah. Meet friends too.
All right. Okay. So that concludes our discussion for today. So I want to thank all three of you for joining us today. This has been very insightful, and we're short on time, so I'll just pass this over to Chase.
All right, once again, thank you, Ms. Ko, Ms. Michelle, and Mr. Stanley for such a comprehensive sharing session and taking time to share their expertise. I also want to thank all of the participants for attending this online workshop. We hope you have found this workshop to be insightful. As we wrap up our event, I want to remind all of the participants that you'll receive your e-certificate via email soon. Last but not least, we'll move on to the last part of our workshop, the photography session. To all participants, kindly turn on your camera. Thank you.
Wait, is someone counting down?
Are we
or
taking
are you guys
off?
speaking? Oh no.
Please do let us know.
Yeah, what's
like
going
3,
on
2,
now?
1,
Yeah.
Yeah, Ethan, you should count down as well. All right, thank you.
Okay, thank you
Thank
guys.
you guys. Thank you for
Thank you
having
guys for
us.
staying through
Today, we
the
hope
whole
to
3
see
hours.
all of you at our next workshop. Thank you, guys.
Thank
Thank
you
you
for
so
having
much.
us.
Yeah, thank you.
Have a good day.
Bye-bye.
Bye-bye.
Bye. Ilsa committee, please stay here. Yusuf, you can stop the recording. Let me know when you are done.